Good morning. It's a pleasure to present to you today for the first day of the Permanent Peoples Tribunal on human rights issues around fracking and climate change. My name's Revel Pointon and I'm a solicitor here in Australia, specialising in environmental law. I work for Australian Community Legal Centre, the Environmental Defenders Office, who provides legal assistance to the community to help them understand and use their rights effectively to protect their land, their well-being and the environment they care about. And I'm joined here today by co-lead attorney, Dr. Evan Hamman.
Thanks, Revel. So my name's Evan Hamman. I'm an environmental lawyer and law academic here located in Queensland, Australia. I write about environmental law, including coal seam gas and land use activities in Australia. And Revel and I have worked in the past for NGOs and communities that are seeking to protect rights in relation to the environment. So this week you're going to hear a lot about human rights, both procedural and substantive human rights, and whether the extraction of gas and the practices of fracking are impacting upon those human rights. We'd like you to consider the words of the Universal Declaration of Human Rights, Article 1, which said almost 70 years ago today, "All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood." So we'd like you and the participants in this tribunal to keep these words in mind as you progress through the week. By virtue of the fact that we have both reason and conscience, we should be able to make decisions as human beings that respect each other as well as the environment that we live in. In addition to human rights, the other important factor this week which will be considered is the rights to nature. So several years ago, the late Thomas Berry, who's one of the founding fathers of the rights of nature movement, said as follows: "We see quite clearly that what happens to the non-human also happens to the human. What happens to the outer world happens to the inner world. And if the outer world is diminished in its grandeur, then the emotional, imaginative, and intellectual spiritual life of the human is also diminished or extinguished. Without the soaring birds, the great forest, the sounds and coloration of the insects, the free-flowing springs, the flowering fields, and the sight of clouds by day and stars at night, we become impoverished in all that makes us human." So there's a deep connection between human rights and rights of nature. We'd like you to remember this also throughout the week. Finally, many Indigenous communities have always understood this connection between human rights and the operation of the natural world. Their rights need particular consideration, and the extraction of fracking, or the extraction of gas and the practices of fracking can have severe impacts on their cultural ties.
In our opening statement today, we'll be going through some of the key concepts and terms that the tribunal should be aware of when listening to the testimonials put before them. We'll also be looking at some background documents around each of the key issues to help you in your deliberations, and an overview of what you should expect to hear this week. We urge the tribunal to keep in mind the words we commenced with, that by virtue of humans having reason and conscience, we have an obligation to better our humanity as well as the earth we rely on. And that includes in making decisions about where and how the extractive industry should be allowed to be undertaken on our earth. The tribunal's purpose is to create a forum for reasoned moral debate around issues of importance to the society and our environment today. We are here to provide a space for those members of civil society and those members of our planet that don't often have the ability to have their voices and issues heard in the decisions that most affect them. So we look forward to the input of civil society and the expertise of the various stakeholders we have in this tribunal this week, and we look forward to the recommendations of the tribunal. Thanks very much.
Thank you.
This is the opening statement from Dr. Evan Hamman and Ms. Revel Pointon. We're lawyers in Australia and we've been asked to be co-lead attorneys for the Permanent Peoples Tribunal on human rights, fracking and climate change. In recent years, fracking and the extraction of unconventional gas and oil from beneath the ground, including beneath the ocean, has caused considerable angst for communities across the globe. The science on which fracking is based is shaky at best. The industry, governments and communities are often left in the dark as to the environmental, social and economic risks that fracking and the extraction of unconventional oil and gas can cause on our livelihoods. The uncertainty around fracking and the misunderstandings around the science have caused considerable angst amongst communities, and it's understandable that protests and community outrage have occurred in places as far afield as Australia, the United States, the United Kingdom, and other parts of the world. A large part of the problem is that we simply don't know the extent of the risks and the extent of the impacts that fracking and the extraction of oil and gas on a mass scale are having on our communities and the environment. Fracking is often associated with other infrastructure as well, including pipelines, processing plants, port developments, and increased development of the fossil fuel industry more generally. One of the most precious resources we have is water, both for drinking and for agriculture, but also for the environment. Fracking can cause unacceptable risks to water supply, including the contamination of underground aquifers. Recent experiences also showed that fracking can impact upon geological formations beneath the ground and even have a risk towards seismic activity such as earthquakes. The process of fracking, or otherwise called hydraulic fracturing, involves injecting water at high pressure and sometimes chemicals down into the rock formations in order to release the gas. It's commonly used for types of gas like shale gas and sometimes for coal seam gas, which is also known as coal bed methane, where the gas is tightly held within the coal seams. The major environmental risks associated with fracking include contamination of the aquifers beneath the ground, contamination of ground surface water, the possibility that gas can escape and ignite, and also the possibility that the salty water which comes up from the ground can impact upon the local cropping land. When the gas is released as a result of a reduction in the pressure, there is often a large amount of water which also comes to the surface. This water is often incredibly salty and at times is stored in large evaporation dams. It is unsuitable for drinking or irrigation. Associated infrastructure can also pose risks to the environment and surrounding communities. The gas often needs to be transported many hundreds of kilometres to a place where it can be used in fuel generation or for export. The clearing of vegetation, the laying of pipelines, the possibility of erosion from this can also cause impacts on communities and the local environment. In places like Australia, associated development such as liquefied natural gas processing facilities are being built on the coast of Australia in order to ship a lot of the gas to overseas markets. In some of these cases, processing facilities are being built in World Heritage areas, for example, Australia's Great Barrier Reef. It should not be forgotten that there are also considerable risks to those people working with and alongside gas and oil extraction activities. In developing countries where regulatory frameworks and rules for occupational health and safety are often underdeveloped, this can cause significant human rights concerns for those people working on those projects. Finally, we shouldn't forget that fossil fuels, including gas, including oil beneath the surface of the ground, are also contributing to increased levels of greenhouse gases in the atmosphere. We have a responsibility for future generations to keep the climate at a stable level. Although gas is often touted as something which is far less dangerous than coal, with around 50% of the emissions still nonetheless a fossil fuel, and the extraction of the gas, along with the associated infrastructure, still contributing to climate change in a negative way.
During this week, as judges, you have been asked to apply the standards of international human rights law and render an advisory opinion on the following 4 fundamental legal questions. First, under what circumstances do fracking and other unconventional oil and gas extraction techniques breach substantive and procedural human rights protected by international law as a matter of treaty or custom? Secondly, under what circumstances do fracking and other unconventional oil and gas extraction techniques warrant the issuance of either provisional measures, a judgment enjoining further activity, remediation relief, or damages for causing environmental harm? Thirdly, what is the extent of responsibility and liability of states and non-state actors for violations of human rights and for environmental and climate harm caused by these oil and gas extraction techniques? And fourthly, what is the extent of responsibility and liability of states and non-state actors, both legal and moral, for violations of the rights of nature related to environmental and climate harm caused by these unconventional oil and gas extraction techniques? Fracking has a wide range of impacts. Therefore, the issues have been broken into 6 subcases through which the prosecution will be arguing. Firstly, the human health case will address the human rights dimensions of adverse impacts on all dimensions of human physical and mental health. The climate impacts case will address all the human rights and earth rights dimensions for both present and future generations of fracking and climate change, including of governments' continued subsidizing of fossil fuels. The environmental, ecosystem, hydrologic, and seismicity cases will address the human rights and earth rights dimensions of adverse environmental, ecosystem, and wildlife impacts, as well as impacts on air, surface water, groundwater, and earthquakes. The public participation case will include the human rights dimensions of public participation, or lack thereof, in decision-making about unconventional oil and gas exploration, extraction, and policy-making. The fuels infrastructure case will address the human rights and earth rights dimensions of exploration, drilling, fracking, extraction, and delivery processes, as well as of the infrastructure needed for transport, storage, and export of product and waste generally. For example, pipelines, storage facilities, waste treatment facilities, wastewater disposal, LNG terminals, compressor stations, etc. Finally, the social cost case will address the human rights dimensions of social and cultural impacts on individuals, families, and communities. As set out by Tom Kearns in his 2017 article, An International Tribunal on the Human Rights Impacts of Fracking, Structure, Grounding, and Purposes, the following legal tests should be applied by the tribunal in hearing the evidence and developing any recommendations in your decision. These tests are representative of those of a human rights court. As to the question of standing, every individual person is considered to have legal standing in international human rights courts. Therefore, there is no restriction as to who can be before the tribunal. As to standards of proof needing to be tested, standards of proof in international human rights courts favour the plaintiff over the state to balance the fact that plaintiffs are often disadvantaged in the evidence they can access to support their case. As to the burden of proof, the burden of proof in human rights courts is on the state in such an action, rather than on the plaintiff, even though the state would be the defendant normally. We will now provide a background as to where human rights norms can be found that can be applied by the tribunal. Human rights norms can be found in a variety of international human rights instruments, including those comprising the International Bill of Rights, being the Universal Declaration of Human Rights, the International Convention on Civil and Political Rights, the International Convention on Social, Economic, and Cultural Rights. Human rights can also be found and provided for through state or regional constitutions, charters, or laws. Human rights can be substantive rights, for example, a right as of life, liberty, property, or reputation, considered to exist for its own sake and to constitute part of the normal legal order of society. Or they can be procedural rights, which are rights that exist to provide a means to enforce substantive rights through legal and governance processes. Examples of substantive human rights that are likely to be raised before the tribunal this week include the right to life, the right to the enjoyment of the highest attainable standard of physical and mental health, a right to a healthy environment, right of self-determination, a right for Indigenous peoples to enjoy their own culture, and the right to safe and healthy working conditions. Examples of procedural human rights that may be raised before the tribunal this week include right to an effective legal remedy, right to access information and public participation, right to equal access to the public service, the right to equal protection of the law, and the right to legal protection against arbitrary or unlawful interference with privacy, family, and the home. The main focus of the PPT is on human rights as a human rights tribunal. However, time will also be given to consider the rights of nature itself through a full day of the tribunal hearings. The rights of nature or earth jurisprudence recognizes that our earth or environmental values, our ecosystems, also have inherent rights that should be recognized and honored, just as we honor the rights of humans. It recognizes the holistic systems of our planet, that all ecosystems on Earth are deeply intertwined, and therefore what is good for human beings must also be balanced against what is good for other species and what is good for the whole planet. While there is a human right to a healthy environment, the case addressing fracking's impacts on ecosystems will be argued primarily from the Earth Charter perspective that all beings are interdependent and every form of life has value regardless of its worth to human beings. Some constitutions also include reference to the rights of nature. This is not a new concept for many Indigenous cultures around the world, for whom the rights of nature are embedded into their worldviews and traditions of living in harmony with nature, and with acknowledgement of the deep connection between all life. For the purposes of the tribunal, the rights of nature features such as water resources, rivers, groundwater basins, etc., and the ecosystems that depend on them will be considered and investigated, amongst other things. There are a variety of documents that we recommend to the tribunal for providing a helpful background to key matters that may assist the tribunal's deliberations. A compendium of scientific, medical, and media findings demonstrating risks and harms of fracking around unconventional gas and oil extraction has been produced by the Physicians for Social Responsibility and Concerned Health Professionals of New York. This is the 5th edition and was produced in March of this year. The compendium provides a compilation of several hundred scientific, medical, and media findings that detail evidence for the risks and harms associated with fracking. The compendium focuses on topics most closely related to the public health and safety impacts of unconventional gas and oil drilling and fracking. The 5th Assessment Report by the Intergovernmental Panel on Climate Change in 2013 and the expected forthcoming updates for 2018-2019 can provide a useful reference point for climate change-related issues to do with unconventional gas and oil. The IPCC, set up in 1988, is a highly respected and renowned international body set up by the World Meteorological Organization and the United Nations Environment Programme. It was set up to assess the science related to climate change to provide policymakers with regular assessments of the scientific basis of climate change, its impacts and future risks, and options for adaptation and mitigation. Their assessment reports present projections of future climate change based on different scenarios and the risks that climate change poses, and discuss the implications of response options. We would now like to introduce the tribunal to various documents that provide helpful background to the human rights norms and laws as related to the issues in consideration by the tribunal. Firstly, the Declaration on Human Rights and Climate Change, produced by the Global Network for the Study on Human Rights and the Environment in May 2016, provides a useful overview of agreed human rights issues arising from climate change. 2 human rights assessments have been undertaken in New York in 2011 and in the UK in 2014, which look directly at the human rights issues arising from fracking for natural gas and other unconventional gas development. These are sure to be of use to the tribunal in their deliberations, given their relevance to the topic in question. UN Special Rapporteur on Human Rights and the Environment, John Knox, has produced a report of his 5 years working in this role, Framework Principles on Human Rights in the Environment, the main human rights obligations relating to the enjoyment of a safe, clean, healthy and sustainable environment. A very useful report indeed. Sister Aine O'Connor from the Mercy Global Action Group has produced a rights-based guide to advocacy directly on human rights law and fracking. The guide aims to contribute to the debate on fracking by outlining how international human rights law can empower and reposition people and communities as rights holders, providing an extensive overview of accountability mechanisms to address threats or harms from fracking. Further helpful background documents by the Tribunal include an outline of Indigenous rights issues provided in the Indigenous peoples, Afro-descendant communities and natural resources, human rights protection in the context of extraction, exploitation and development activities report by the Inter-American Commission on Human Rights, produced in 2015. An overview has been given of rights of nature issues in Fighting for Our Shared Future, Protecting Both Human Rights and Nature's Rights in their 2016 update, produced by the Earth Law Centre. Also, the United Nations Toolkit on the Right to Health may be helpful for the Tribunal. We will now provide an overview of the testimony and evidence that will be put before the Tribunal over the coming week. For the rest of today, you will hear about various pre-tribunals that have been held in preparation for this Tribunal hearing. Firstly, you'll hear from Rick Sally, who will present on the pre-tribunals held in Athens and Youngstown in Ohio in the summer of 2017. These tribunals were held in an effort to gather and correlate data to submit to the UN Human Rights Council, charging the state of Ohio and the US federal government with human rights violations through their unchecked allowance of the oil and gas industry to operate when their actions are directly infringing upon citizens' rights, health, and the environment. You will then hear from Shay Dougal and Benedict Coyne of Australia, who will be presenting on outcomes and issues raised in the Australian pre-tribunal. On Tuesday, the morning will start with presentations on the rights of nature by the Earth Law Alliance's Lisa Mead. The submissions around rights of nature will be arguing that unconventional oil and gas extraction violates the rights of nature to exist, thrive, regenerate, and evolve, and that both state and non-state actors are responsible, accountable, and liable for these violations. Whereas other submissions and testimonials to the Tribunal will be focusing on the human rights impacts of climate change and fracking, these submissions will focus mainly on harms to nature and climate. Natalie Eddy and Bruce Basil will then provide presentations from Earthworks, who work closely with communities directly impacted by fracking and oil and gas extraction in the United States. In their submissions, they have focused on the first two questions of the four. They will argue that the precautionary principle needs better and stronger application in current and future gas and oil development, and that the burden of proof should be shifted to the industry to demonstrate whether harm is being caused. After lunch, you will hear from Robin Bronin, who will provide testimony as to climate-forced migration in Alaska. Robin will present on the demand for and difficulty in climate-forced community relocation, arguing that the continued increase in greenhouse emissions is forcing those who have least contributed to the climate crisis to make the extremely difficult decision to leave the homes where they lived for millennia. Robin will be followed by Seal Smith and Eunice Brower from Alaska Climate Action Network, who will continue consideration of issues in Alaska from fracking in the native village of Nuiqsut. Raymond Cusson, representing the issues arising from hydraulic fracturing on the west coast of Newfoundland, Canada, has unfortunately had to cancel his personal testimony to the Tribunal this week, but his written submissions stand, and we encourage the judges to review these important submissions. Raymond offers insights into how small communities in the oil-dependent Canadian province of Newfoundland and Labrador organize community resistance to fracking in an attempt to protect their communities, their human rights, and the increased potential impacts on climate change. You will then hear from Amanda Kennedy from Australia, who will be presenting on issues around Australian state and federal laws regulating unconventional gas and oil extraction from the perspective of procedural human rights. You will then hear from Lakshmi Fjord and Irene Leach, who will be presenting on the Charlottesville Peoples Pre-Tribunal in Virginia, USA. In October 2017, a day-long tribunal was held to collect testimonies about the human and environmental impacts of 2 interstate fracked gas pipeline projects already under construction through parts of Virginia, West Virginia, and North Carolina. This will be followed by Andy Georgiou presenting from Food and Water Watch and Food and Water Europe. After lunch, Dr. Michelle Maloney of the Australian Earth Laws Alliance will present further on the rights of nature. Michelle will continue to present on the need for rights of nature and not just human rights to be better protected from the impacts of the unconventional gas industry. Declan Doherty, also from Australia's Environmental Defenders Office in Western Australia, will present submissions from the experience of WA, where an inquiry has been commissioned by the WA government to investigate the risks of fracking. This is ongoing. Declan will focus on the first legal question, being the circumstances in which fracking activities and the risks they pose to the natural environment, health, communities and Aboriginal heritage breach substantive and procedural human rights protected by international law. Vanessa Brown from Vermont 350 will end the day with some discussion around philosophies of druids and unconventional oil and gas, amongst other submissions. 350 Vermont is a non-profit organisation that organises, educates and supports people in Vermont to work together towards climate justice, resisting fossil fuels, building momentum for alternatives and transforming our communities towards justice and resilience. On Thursday, Simona Perry will start by presenting her field research, being evidence files submitted on behalf of local communities and families across the USA over 9 years. These families have had their human rights violated as a result of fracking and other unconventional oil and gas developments, including infrastructure developments and associated climate change impacts. Over the past 9 years, social, environmental, and community health scientists have been closely documenting the consequences of these activities to local communities through various scientific perspectives, which Simona will present on. This will be followed by Megan Hunter presenting on a freshwater accountability project, a non-profit organisation with a mission to preserve and protect freshwater supplies through education and community action, and is dedicated to promoting health and well-being by protecting the environment. Since its origins, Freshwater has served as a community advocate, helping individuals and communities impacted by fracking to organise, educate and participate in environmental decisions that affect them. Ali Rosenblatt will then present from Rogue Climate. Based in Jackson County in Southern Oregon, Rogue Climate works in many of the rural communities impacted by the proposed Pacific Connector fracked gas pipeline and Jordan Cove LNG export terminal. Jody McCaffrey will follow with a presentation also on Jordan Cove, with a citizen environmental and human rights assessment of exporting hydraulic fractured natural gas. Daniel Taylant will follow from the Centre for Human Rights in the Environment on the issue of human rights violations and climate change inducing invisible methane and deadly volatile organic compounds and other pollutants emitted by the oil and gas sector, which can be identified with infrared technology. The afternoon will then provide time for attorneys and judges to answer questions posed by the judges and to engage in general discussion. On Friday, the morning will start with Maura Stevens providing testimony from Coalition to Protect New York, a coalition formed in 2010 by a group of central New York individuals and grassroots organizations in response to the growing threat of unconventional shale gas activities to their health, environment, communities, and ways of life. Maura's submissions discuss the evolution of community understanding, concern, and activation in response to the issues that they were facing from increasing unconventional gas activities being proposed around them. I will then return to appear before you to present closing submissions for the tribunal. As judges, you will then have the opportunity to consider and provide any recommendations and/or statements you might choose to offer in resolution of this Permanent Peoples Tribunal hearing.
This concludes our opening address. Revel and I were greatly honoured to be able to provide this information to you, and thank you for listening. We'd like to finish with the words of Article 1 of the United Nations Universal Declaration of Human Rights. This is the point where we first started. All human beings are born free and equal. We are endowed with reason and conscience. We are therefore able to reason through logical arguments and also show compassion to our fellow human beings and those of the environment that we rely on for survival. We hope that you take these words through with you throughout the week.